Hi YouTube, Legal Doug here. Let's take a look at another U.S. Supreme Court case in the area of constitutional law. The one today is Graham v. Connor. It's a 1989 case. Citation is 490 U.S. 386. And it was decided on May 15th, 1989. And it's on appeal from the Fourth Circuit, which at that point in time I believe was considered a very conservative court. Now probably leaning a little bit more liberal. And it's a unanimous decision. And let's take a look at who the justices were on that. Always try to give some context on who actually made this decision. It's always interesting and I guess important to consider when there's a unanimous decision. Seems to be everybody on the court's pretty clear on this. So we've got William Rehnquist is writing the opinion. He's a conservative appointed by Richard Nixon. William Brennan, a very well-known, very liberal justice appointed by Eisenhower, joins in that. But he also joins in the concurrence that you'll see at the end of this. Byron White was appointed by Kennedy, more of a centrist, I think, maybe leaning conservative. Thurgood Marshall, a pretty well-known liberal on the court. He also joins in the concurrence along with the opinion. Harry Blackmun, another well-known liberal on the court in those days, appointed by Richard Nixon. Also, I believe Harry Blackmun, wrote the concurrence. We'll see that in a second. John Paul Stevens, at that point, more of a centrist than a liberal, I think, appointed by Ford. Sandra Day O'Connor, Scalia, and Kennedy, all appointed by Reagan. Scalia being the clear conservative of that group. The other two were often in that middle moderate group on the court at that time. So that's who decided this case. Probably a more conservative leaning court, but again, a unanimous decision, which is something we should always consider. Okay, it's not a terribly long case. Let's go ahead and just go through the opinion itself. Opinion written by Justice Rehnquist, the Chief Justice. So this case requires us to decide what constitutional standard governs a free citizen's claim that law enforcement officials used excessive force in the course of making an arrest. That's the issue here, excessive force by law enforcement. In the course of making an arrest, investigatory stop, or other seizure of his person. We hold that such claims are properly analyzed under the Fourth Amendment's objective reasonableness standard, rather than under a substantive due process standard. So the court is all coming together here to say that the Fourth Amendment is the analysis that should be done here, not the 14th Amendment under due process, under a due process standard. Just a quick note on the 14th Amendment. You hear the reference in this case to due process in the due process clause. Well, the 14th Amendment, which was adopted after the Civil War in 1868, in an attempt to grant rights to former slaves more clearly, I guess, and to apply constitutional protections to the states as well as to the national government, included two primary clauses, the due process clause and the equal protection clause. And both of those you see come up as specific issues in given cases. In this particular case, there's a lot of discussion of the due process clause. So when you see that, when you see due process clause, or if you see equal protection clause, those are both referring to the 14th Amendment. Just wanted to clarify that point if that was not clear. In this action under 42 U.S.C. 1983, which we see over and over in these cases, petitioner DeThorne Graham seeks to recover damages for injuries allegedly sustained when law enforcement officers used physical force against him during the course of an investigatory stop. Because the case comes to us from a decision of the Court of Appeals affirming the entry of a directed verdict for respondents, we take the evidence hereafter noted in the light most favorable to petitioners. Just legal standard for dealing with this type of appeal. On November 12, 1984, Graham, a diabetic, felt the onset of an insulin reaction. He asked a friend, William Berry, to drive him to a nearby convenience store so he could purchase some orange juice to counteract the reaction. Berry agreed, but when Graham entered the store, he saw a number of people ahead of him in the checkout line. Concerned about the delay, he hurried out of the store and asked Barry to drive him to a friend's house instead. Okay, had to get my yard guy finished. Should be okay now. So continuing on, Respondent Connor, an officer of the Charlotte, North Carolina Police Department, saw Graham hastily enter and leave the store. The officer became suspicious that something was amiss and followed Barry's car. About 1/2 mile from the store, he made an investigative stop. Although Barry told Connor that Graham was simply suffering from a sugar reaction, the officer ordered Barry and Graham to wait while he found out what, if anything, had happened at the convenience store. When Officer Connor returned to his patrol car to call for backup assistance, Graham got out of the car, ran around it twice, and finally sat down on the curb, where he passed out briefly. In the ensuing confusion, a number of other Charlotte police officers arrived on the scene in response to Officer Connor's request for backup. One of the officers rolled Graham over on the sidewalk and cuffed his hands tightly behind his back, ignoring Barry's pleas to get him some sugar. Another officer said, "I've seen a lot of people with sugar diabetes that never acted like this. Ain't nothing wrong with the MF but drunk. Lock the SB up." Several officers then lifted Graham up from behind, carried him over to Barry's car, and placed him face down on its hood. Regaining consciousness, Graham asked the officers to check in his wallet for a diabetic decal that he carried. In response, one of the officers told him to shut up and shoved his face down against the hood of the car. 4 officers grabbed Graham and threw him headfirst into the police car. A friend of Graham's brought some orange juice to the car, but the officers refused to let him have it. Finally, Officer Connor received a report that Graham had done nothing wrong at the convenience store, and the officers drove him home and released him. At some point during his encounter with the police, Graham sustained a broken foot, cuts on his wrists, a bruised forehead, and an injured shoulder. He also claims to have developed a loud ringing in his right ear that continues to this day. He commenced this action under 42 U.S.C. 1832 against the individual officers involved in the incident, all of whom are respondents here, alleging that they had used excessive force in making the investigatory stop in violation of rights secured to him under the 14th Amendment, the Due Process Amendment, to the United States Constitution, and 42 U.S.C. 1983, which provides for an action if there's violation of constitutional rights under color of law by the police. The case was tried before a jury. At the close of petitioner's evidence, respondents moved for a directed verdict. So they're saying, don't even let this go to the jury. Court, make a decision. The state feels like it's clearly entitled to win here. In ruling on that motion, the district court considered the following 4 factors, which it identified as the factors to be considered in determining when the excessive use of force gives rise to a cause of action under Section 1983. And these are important factors. These are still applicable. Number 1, the need for the application of force. Did you need to actually use force? Was he resisting in some way? The relationship between that need and the amount of force that was used. Did he twist and you clubbed him with your baton or something? The extent of the injury inflicted. And number 4, whether the force was applied in a good faith effort to maintain and restore discipline or maliciously and sadistically for the purpose of causing harm. Finding that the amount of force used by the officers was appropriate under the circumstances, that there was no discernible injury inflicted, and that the force used was not applied maliciously or sadistically for the very purpose of causing harm, but in a good faith effort to maintain or restore order in the face of a potentially explosive situation, the district court granted respondents' motion for a directed verdict. So the officers won at that level, the district court level. They're saying they acted reasonably under those circumstances. A divided panel of the Court of Appeals of the Fourth Circuit affirmed, saying, yeah, we agree with the court on that. The majority ruled first that the district court had applied the correct legal standard in assessing petitioner's excessive force claim. Without attempting to identify the specific constitutional provision under which that claim arose, the majority endorsed the 4-factor test applied by the district court as generally applicable to all claims of constitutionally excessive force brought against governmental officials. The majority rejected petitioner's argument based on circuit precedent that it was error to require him to prove that the allegedly excessive force used against him was applied maliciously and sadistically for the purpose of causing harm. Finally, the majority held that a reasonable jury applying the four-part test it had just endorsed to petitioner's evidence could not find that the force applied was constitutionally excessive. The dissenting judge argued that this court's decision in Terry v. Ohio, which we here refer to in virtually every case, and Tennessee v. Garner, required that excessive force claims arising out of investigatory stops be analyzed under the Fourth Amendment's objective reasonableness standard. We granted certiorari, so we agreed to, this is one of the few cases that the Supreme Court says, yeah, we need to take a look at this case. 15 years ago in Johnson v. Glick, which I will cover in the near future, the Court of Appeals for the Second Circuit addressed a Section 1983 damages claim filed by a pretrial detainee who claimed that a guard had assaulted him without justification. In evaluating the detainee's claim, Judge Friendly applied neither the Fourth Amendment nor the Eighth, the two most textually obvious sources of constitutional protection against physically abusive governmental conduct. Instead, he looked to substantive due process, holding that quite apart from any specific of the Bill of Rights, application of undue force by law enforcement officers deprives the suspect of liberty without due process of law. As support for this proposition, he relied upon our decision in Rochin v. California, which uses the due process clause to avoid a state criminal conviction based on evidence obtained by pumping the defendant's stomach. Due process clause, the 14th Amendment. If a police officer's use of force, which shocks the conscience, could justify setting aside a criminal conviction, Judge Friendly reasoned a correctional officer's use of similarly excessive force must give rise to a due process violation actionable under Section 1983. Judge Friendly went on to set forth four factors to guide courts in determining whether the constitutional line has been crossed by a particular use of force. The same four factors relied upon by the courts below in this case, and the ones we just went over. In the years following Glick, the vast majority of lower federal courts have applied its four-part substantive due process test and indiscriminately to all excessive force claims lodged against law enforcement and prison officials under Section 1983, without considering whether the particular application of force might implicate a more specific constitutional right governed by a different standard. Indeed, many courts have seemed to assume, as did the courts below in this case, that there is a generic right to be free from excessive force, grounded not in any particular constitutional provision, but rather in basic principles of Section 1983 jurisprudence. We reject this notion that all excessive force claims brought under Section 1983 are governed by a single generic standard. As we have said many times, Section 1983 is not itself a source of substantive rights, but merely provides a method for vindicating rights elsewhere conferred. Federal rights elsewhere conferred. In addressing an excessive force claim brought under Section 1983, analysis begins by identifying the specific constitutional right allegedly infringed by the challenged application of force. So they're saying you don't sue them under 1983 because they violated 1983. You sue them for violation of some other constitutional right, and you use 1983 to address that. In most cases, that will be either the Fourth Amendment's prohibition against unreasonable seizures of the person or the Eighth Amendment's ban on cruel and unusual punishments, which are the two primary sources of constitutional protection against physically abusive governmental conduct. The validity of the claim must then be judged by reference to the specific constitutional standard which governs that right, rather than to some generalized excessive force standard. See Garner, excessive force to effect arrest analyzed under Fourth Amendment standard, and Willie v. Albert's claim of excessive force to subdue victim, prisoner analyzed under Eighth Amendment standard. Whereas here, the excessive force claim arises in the context of an arrest or investigatory stop of a free citizen, it is most properly characterized as one invoking the protections of the Fourth Amendment. So we're not in a prison situation where the guards are just beating up on somebody and that's an Eighth Amendment violation. We're talking about a citizen who's been stopped out in public, and the Fourth Amendment is what's applicable here, which guarantees citizens the right to be secure in their persons against unreasonable seizures of the person. This much is clear from our decision in Garner. In Garner, we addressed the claim that the use of deadly force to apprehend a fleeing suspect who did not appear to be armed or otherwise dangerous violated the suspect's constitutional rights notwithstanding the existence of probable cause to arrest. Although the complaint alleged violations of both the Fourth Amendment and the Due Process Clause, we analyze the constitutionality of the challenged application of force solely by reference to the Fourth Amendment's prohibition against unreasonable seizure of the person, holding that the reasonableness of a particular seizure depends not only on when is it made, but also how is it carried out. Today we make explicit what was implicit in Garner's analysis and hold that all claims that law enforcement officers have used excessive force, deadly or not, in the course of an arrest, investigatory stop, or other seizure of a free citizen should be analyzed under the Fourth Amendment and its reasonableness standard rather than under a substantive due process approach. Because the Fourth Amendment provides an explicit textual source of constitutional protection against this sort of physically intrusive governmental conduct, that amendment, not the more generalized notion of substantive due process, must be the guide for analyzing these claims. Determining whether the force used to effect a particular seizure is reasonable under the Fourth Amendment requires a careful balancing of the nature and the quality of the intrusion on the individual's Fourth Amendment interests against the countervailing governmental interests at stake. Our Fourth Amendment jurisprudence has long recognized that the right to make an arrest or investigatory stop necessarily carries with it the right to use some degree of physical coercion or threat thereof to effect it. Because the test of reasonableness under the Fourth Amendment is not capable of precise definition or mechanical application, however, its proper application requires careful attention to the facts and circumstances of each particular case, including the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. In C. Garner, the question is whether the totality of the circumstances justifies a particular sort of seizure. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. See Terry. The Fourth Amendment is not violated by an arrest based on probable cause, even though the wrong person is arrested, nor by the mistaken execution of a valid search warrant on the wrong premises. With respect to a claim of excessive force, the same standard of reasonableness at the moment applies. Not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, violates the Fourth Amendment. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. As in other Fourth Amendment contexts, however, the reasonableness inquiry in an excessive force case is an objective one. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them, without regard to their underlying intent or motivation. And then another reference to Terry. In analyzing the reasonableness of a particular search or seizure, it is imperative that the facts be judged against an objective standard. Not what did the police officer think at that time, but what would a reasonable police officer in that situation do? An officer's evil intentions will not make a Fourth Amendment violation out of an objectively reasonable use of force, nor will an officer's good intentions make an objectively unreasonable use of force constitutional. That's the key to this whole case right there, those sentences. Because petitioner's excessive force claim is one arising under the Fourth Amendment, the Court of Appeals erred in analyzing it under the four-part Johnson v. Glick test. That test, which requires consideration of whether the individual officers acted in good faith or maliciously and sadistically for the very purpose of causing harm, is incompatible with proper Fourth Amendment analysis. We don't really care what the cop was thinking at the time he acted, good or bad. It just was his action reasonable in the circumstance? So we do not agree with the Court of Appeals' suggestion that the malicious and sadistic inquiry is merely another way of describing conduct that is objectively unreasonable under the circumstances. Whatever the empirical correlations between malicious and sadistic behavior and objective unreasonableness may be, the fact remains that malicious and sadistic factor puts in issue the subjective motivations of the individual officers, which our prior cases make clear has no bearing on whether a particular seizure is unreasonable under the Fourth Amendment, And I keep thinking about them refusing his orange juice on this. Like, what was their intent there? That's not really a part of the claim here, but that mindset keeps coming up to me. Nor do we agree with the Court of Appeals' conclusion that because the subjective motivations of the individual officers are of central importance in deciding whether force used against a convicted prisoner violates the Eighth Amendment, it cannot be reversible error to inquire into them in deciding whether force used against a suspect or arrestee violates the Fourth Amendment. Differing standards under the Fourth and Eighth Amendments are hardly surprising. The terms cruel and punishments clearly suggest some inquiry into a subjective state of mind, whereas the term unreasonable does not. So that prison situation, the guard beating the prisoner, that would actually take a look at subjective intent there, know what the court is saying. Moreover, the less protective Eighth Amendment standard applies only after the state has complied with the constitutional guarantees traditionally associated with criminal prosecutions. The Fourth Amendment inquiry is one of objective reasonableness under the circumstances, and subjective concepts like malice and sadism have no proper place in that inquiry. Because the Court of Appeals reviewed the district court's ruling on the motion for a directed verdict under an erroneous view of the governing substantive law, its judgment must be vacated and the case remanded to that court for reconsideration of that issue under the proper Fourth Amendment standard. So the court's not saying that they were necessarily wrong below in their conclusion. They're saying that they were wrong below in the analysis that they performed on that. They used the wrong standard. It should have been an objective standard to determine whether there's a claim here or not. Okay, so that's the opinion, and again, a unanimous opinion. But let's take a look at the concurring opinions as well. So the three more liberal justices on the court are saying, yeah, we agree with that objective standard in Fourth Amendment analysis, but we think that there's more that could be used here. And so we'll just go ahead and read through that. So Justice Blackmun, with whom Justice Brennan and Justice Marshall join, concurring in part and concurring in the judgment. I join the court's opinion insofar as it rules that the Fourth Amendment is the primary tool for analyzing claims of excessive force in the pre-arrest context, and I concur in the judgment remanding the case to the Court of Appeals for reconsideration of the evidence under reasonableness standards. So they agree with all of that. In light of respondents' concession, however, that the pleadings in this case properly may be construed as raising a Fourth Amendment claim, I see no reason for the court to find it necessarily further to reach out to decide that pre-arrest excessive force claims are to be analyzed under the Fourth Amendment rather than a substantive 14th Amendment due process standard. He's saying one does not preclude the other. I also see no basis for the court's suggestion that our decision in Garner implicitly so held. Nowhere in Garner is a substantive due process standard for evaluating the use of excessive force in a particular case discussed. There is no suggestion that such a standard was offered as an alternative and rejected. And that's why it's always a good idea to go back and read these other cases. You know, attorneys, when they're trying to make an argument in a brief, will say a court said a particular thing in a case. You go back and read it, and oftentimes it really doesn't seem to say what they're saying it says. I think a Supreme Court justice isn't above, but misstating a little bit what's in there. I don't know one way or the other on Garner, but it's always important to see what they're referencing like that. So in this case, petitioner apparently decided that it was in his best interest to disavow the continued applicability of substantive due process analysis as an alternative basis for recovery in pre-arrest excessive force cases. So he's just saying he just made a litigation strategy decision to drop the substantive due process side of his argument. His choice was certainly wise as a matter of litigation strategy in his own case, but does not, indeed cannot be expected to serve other potential plaintiffs equally well. It is for that reason that the court would have done better to leave that question for another day. So the Blackmun is saying this really need to have decided that at all here. That was unnecessary to make this decision. I expect that the use of force that is not demonstrably unreasonable under the Fourth Amendment only rarely will raise substantive due process concerns. But until I am faced with a case in which that question is squarely raised and its merits are subjected to adversary presentation, I do not join in foreclosing the use of substantive due process analysis in pre-arrest cases. Again, Amendment 14th Amendment. And so that's it. That's a short concurrence opinion explaining that he agrees with the Fourth Amendment analysis, but really this could have also been looked at under 14th Amendment due process clause. As always, I also suggest that you read the notes. There's always pretty substantive information in the notes here, references to some other cases that may be helpful as well. So that is the case for this week. I think it's a pretty relevant one, a timely one right now. We've got a situation with the guy who crossed the street to get the Coke and jaywalked, and you've seen a lot of coverage of that lately. I think that's gonna this case is gonna be coming up in that one as well. But that's what I've got for this week. I appreciate your time. If this is interesting to you at all, please give me a like. If I don't have support on this, then YouTube will not put these videos in front of anybody. So it would be helpful if you could do that. If you could, if you're interested in these cases, if you could subscribe and get notification that I've got a new one out, that's also always helpful to me. And again, any comments that you have, good or bad, one way or the other, I'm happy to engage in the comment section as well. So again, thank you for your time, and hopefully we'll see you soon with another case.